Good morning. Welcome to our November case call. We'll call our first case, People versus Sale. This is a 15-minute mini and oral argument on the application. You have 2 minutes of a free fire zone, which you may waive, and if you are going to reserve time, we ask that you keep track of that yourself.
All right, thank you, Your Honor. Good morning. May it please the court. Tim Doman on behalf of Tyler Sale. As the court is aware, this is a CSC 1 case where my client is serving a minimum of 25 years in prison based entirely on the allegations and credibility of the complainant. In other words, the trial in this case was a classic one-on-one credibility contest, the kind of case where this court has repeatedly said a piece of evidence on one side or the other could tip the scales. And here it's our position that the jury was deprived of a very significant piece of impeachment, and that is just a few months before the allegations in this case surfaced, she had falsely accused her own father of physically assaulting her. Under MRE 608B, the defense was entitled to cross-examine the complainant about this specific instance of untruthfulness, and we believe that the trial court erred by excluding it and that the error was not harmless. I welcome the court's questions at any time. So the first question the court has asked the parties to address was there in fact an error by the trial court? And I think what this really boils down to was, does the record show that there was an inconsistency, a specific instance of untruthfulness? And obviously it's our position that it does. And I think taking the sum total of the record that was made outside the presence of the jury, what you get is that the complainant told the volleyball coach that her father intentionally hit her, and then when confronted by CPS, told the CPS worker that no, actually it was accidental. And so I think the record does demonstrate that inconsistency. And as I was re-reviewing in preparation for today, I think I may have even undersold the clarity of the record on this point. I think just taking the first back and forth with defense counsel and the complainant, it does establish this inconsistency. I'm paraphrasing here, but the attorney asks, did you tell the volleyball coach that your father hit you? Complainant says yes, and then later the attorney asks, did you tell CPS that it was accidental? And the complainant says yes. So I think on its face we have this inconsistency. And the other point, I made it in my brief, but maybe didn't emphasize it as much as I could have. I think just the fact that CPS gets involved here, I think a reasonable juror could infer that whatever specific words the complainant used to describe this contact with the father to the volleyball coach, that it connoted some type of intentional abusive act. And so where I think the lower courts went wrong on this is that they didn't understand exactly what the defense was driving at. This was never about, was this a light slap versus a heavy hit? This was always about, was this contact with the father intentional or accidental? And I think the trial attorney made that point on the record during trial. So at the end of the day, I think the record does establish that there was a specific instance of untruthfulness and that the trial court erred by not allowing this testimony in under MRE 608B. Now, moving on to...
Would you agree that defense counsel did a pretty good job in impeaching the victim on other inconsistent statements about a variety of events and details related to this specific offense in this issue?
Oh, I agree. There was a lot of impeachment. I think the distinction is there was a lot of impeachment.
Okay, so I just want to make sure you agree on that. So if that's the case, why would we... Help me process why I'd come to the conclusion that a jury might reach a different result on this question of a potential inconsistent statement for something that has nothing to do with the conduct at issue here. It seems to me that the impeachment was very vigorous, and based on that, I'm having a hard time processing how the jury comes to a different result, even if they hear, yeah, I told the coach hit, I told CPS unintentional, which, by the way, a hit might be unintentional, but I'll give it to you that it's intentional. I'm having a hard time processing that. Can you help me work through that?
So I think a lot of the other impeachment, like Your Honor said, was about inconsistent statements that the complainant had made about the abuse itself between what she reported to police, to these other witnesses, versus prelim versus trial. And I think a lot of that can be chalked up to, well, this is a young witness. and maybe she's not intentionally misstating anything, she's just mistaken. The impeachment at issue here was of a different type. This was a separate, specific instance of untruthfulness, and it establishes that, under our theory, that the complainant made a false accusation.
All right. Can't the same thing apply to this testimony? It's a young witness who doesn't want to see her father charged with a crime.
I think that really what this shows is that the complainant has a character for coming up with the idea to make a false accusation in the first place. It shows that, and again, we're talking about specific instances to show character, it shows that she has a character that she would make up something like this in the first place, that her mind would go there. And certainly under our theory, right, she retracted what she accused her father of, but a false allegation of criminal sexual conduct, once that train leaves the station, it's a lot harder to take back. So on the harmless error point, I think just how close, I think the starting point is just how close this case was, and I think that's evident from just the jury's struggle here. And obviously, as we were discussing, the question becomes, what would the jury have made of this? And what the Court of Appeals said is, well, the complaint was impeached on a lot of other points already, so if you toss in one more piece of impeachment, we don't think it's going to make a difference. And you see this kind of analysis in a lot of decisions from the Court of Appeals, especially in CSC cases. And I think it's important for this court to hopefully issue an opinion explaining why that's wrong. I think first, it's just a logical fallacy to say that because my client was convicted at a trial where this evidence wasn't presented, that he would also be convicted at a trial where this evidence was presented. And not only that, it's inconsistent with what this court said in Armstrong, where the court held even where a complainant has been thoroughly impeached, that doesn't mean that an additional attack on credibility might not change the outcome. And I think it was Your Honor who wrote that opinion, so I think certainly we would incorporate the analysis there. And I think the key point here is that not all impeachment is created equal, right? There are going to be some minor points and there are going to be some major points, and it's our position here that this would have been a particularly potent piece of impeachment. The fact that the complainant would falsely accuse her own father of physical assault, again, as we were discussing, suggests a character for untruthfulness that makes it more likely that she would also falsely accuse my client. And again, this wasn't just another piece of impeachment. It shows that the complainant has a specific knack for making false criminal accusations. So not only do we have all the different inconsistencies, now we have evidence that she's made false criminal allegations in the past, which the other impeachment at this trial didn't necessarily go toward. So obviously, as I've discussed, I think this was a powerful piece of impeachment that would have changed the outcome of the trial.
You agree the trial judge, in considering this, makes the call under an abuse of discretion standard, right?
Yes, Your Honor.
How do we get from a different trial judge might have permitted this impeachment, this one didn't? What takes it to the next level of saying almost every trial judge would have allowed this, and this is an abuse of discretion?
So I think the key point here is that the trial court judge misunderstood the nature of the inconsistency. I think he compared it to blue versus light blue, but really we were talking about, again, intentional versus accidental. So I think there was clear error in the appraisal of the facts, as I wrote in my brief. If you have an evidentiary ruling that is shaded by a clearly erroneous view of the facts, then you get to an abuse of discretion.
That takes me back to the point that I conceded to you earlier. How do we get from hit, the word hit, which is very possible, to hit intentionally?
So again, I think just the fact that CPS gets involved, that supports a reasonable inference that whatever she reported to the volleyball coach did describe something intentional, abusive. The other thing is that the prosecutor here was obviously well prepared for this, objected right away, and even, I don't want to say conceded, but there was an admission, at least, that there was, I think he called it an exaggeration. So it wasn't, and the other thing is that the complainant had ample opportunity during this back and forth to say, wait a minute, no, you're misconstruing what I told the volleyball coach. So I think taking all of that together, we get to that point.
Thank you.
Also, help me understand this report to the, you call it a report to the volleyball coach. We don't have much facts other than the exchange on the record, but it appears that she had some issue with her hearing, and when she discussed that with her coach, and she attributed that to being hit by her father. Is that what I understand?
I think that's correct, Your Honor.
That's a little different than a sort of a false report intended to get her father in trouble with the authorities, isn't it? I mean, it's a discussion between her and her coach on why she can't hear so well today. Is that seems quite a bit different than a young child who goes to the authorities or reports with the intention of there being some consequence for the adult. Am I missing something?
No, I think it shows, if anything, how kind of cavalier this was, that her ear is clogged and she tells her volleyball coach that, oh, it's because my dad hit me. So I take the point that this wasn't, she didn't report to the authorities, but just announcing to an authority figure that my dad hit me. And again, this is not a...
Well, she never, as you've already indicated, she never later indicated to CPS that her dad didn't hit her, did she?
Right, she indicated it was accidental.
Right. Should it matter to us that I assume you think the later statement was truthful, or do you not have a position on that?
I don't necessarily think it matters from our position. The importance for us is that there's an inconsistency. So either she was lying in the first instance or the second.
Well, lying's a strong word, but to a teenager who's having a casual exchange with her volleyball coach, but should it matter to us that when she has the later, more serious interaction with CPS, she minimizes the conduct instead of exaggerating it at that point? Does that bear on her credibility when it shows that when confronted by the authorities, she actually doesn't want her father to get into trouble? I think that's a fair.
Well, I think a couple things. First, it's often going to be the case where you have some type of false allegations that are false. We know they're false because the complainant recanted, right? So if she had told CPS, oh no, it was intentional, whether that's true or not, we're not getting into it. So I think any time you have, or most of the time, where you have a false allegation like this, it's going to be because the complainant came clean in the end. So I don't think that necessarily is a strike against us.
Having a hard time with those big words you're using. These are false allegations that she recanted. I mean, this was a casual exchange with her coach that that the coach thought was concerning enough to involve apparently the authorities. The coach has a duty to report. But once those authorities are engaged, the response is, no, this actually was not, it wasn't intentionally. That doesn't sound like a big falsehood, recanting of testimony, all these big words you're using. What am I missing?
Well, I will say I don't think the record necessarily shows that this was, just some casual statement that was made as an aside to the volleyball coach. And I take your point, Your Honor, that the record here is not as pristine maybe as it could be. I think part of that is because the parties knew what they were arguing over, right? So, but I think with the record that we have, I don't think it shows that this was just some aside that the volleyball coach took the wrong way. I think it shows that she made a serious report to the volleyball coach who felt compelled to then report it to CPS. I see I have a minute left, so I'll save that time for rebuttal. Thank you.
My name is Jake Jennison from the Adel County Prosecutor's Office representing the state of Michigan. Ladies and gentlemen, and your honors, I want to bring to your attention the two issues that this court asked us to discuss further today. Number one is the issue of 608. And the people are taking the position that in regards to 608 and whether or not the issue is the severity of the strike or whether or not there was an inconsistency, I want to draw the court's attention to page 224 of the transcripts, in which the court specifically asked defense counsel, are you saying that she lied about the severity of the hit? And defense counsel's argument is not yes, but defense counsel's argument and her response is absolutely. And that is what the judge is evaluating for 608. And that allows the judge to then get into, well, the car is blue, is it light blue? All of those things, the record does not indicate that there is a lie here. So 608, in my argument and the people's argument, is that this is not a situation regarding whether or not it was accidental or whether or not it was intentional, but the severity of the strike, and that's what the transcript and that's what the record reads. And when evaluating 608, the judge is evaluating whether or not it's relevant. As Your Honor pointed out, the other impeachment specific topics and how defense counsel impeached our victim in this case, and how is this specific incident going to move the ball forward, and that's what the trial court, Judge Halsing, indicated, basically saying this is not relevant. And moving forward, even if the court does find that there was an issue with 608 and that it went beyond the principled outcomes, evaluating Douglas and evaluating Armstrong, those situations, Your Honors, are directly related to the victim and to other parties. This is a collateral matter involving a father and a daughter, not the defendant or the victim, but this is a situation that is collateral in nature, ladies, or Your Honors, and that's the argument in regards to Armstrong as well as to Douglas, because those situations in Armstrong in which the victim made clear that after there was a violent rape and a violent assault, that there were no other communications between the two parties other than a few phone calls. And Armstrong discusses further, all impeachment testimony is not created equal, as defense counsel indicated to Your Honors previously. And that's the truth, because that is directly related to the victim and to the defendant. This is a situation involving involving the father and the victim in the case. And as I indicated, ladies or Your Honors, that is certainly a collateral matter. Moving on.
I thought it was a very concise argument.
Just going to keep it straight and to the point. I think the record indicates that. As far as 608 is concerned, I don't know how much clearer the record can be when the judge is pointing out, and is specifically asking defense counsel, so you're saying that the issue is the severity of the strike. And defense counsel's, like I said previously, is not yes, it's absolutely.
I know you said the page number, but I missed it. As long as you're bringing it back, save my law clerk some time.
Yes, page 224, line 20. The court, you're saying she lied about the severity of the strike. Defense counsel's argument or response is absolutely. She exaggerated something that's so serious, and continues on. That right there, as far as 608 is concerned, I think puts a stop to that argument, because then we're not getting into the matter of whether or not it was accidental or intentional, but that certainly is a situation that we are looking at. Okay, so now we're going to get into the severity of the strike and how hard it was, and the judge's argument in response, well, not argument, for lack of a better word, but his responses was the car is blue, was it light blue, was it dark blue? And defense counsel in their brief talked about, the definitions of a slap, of a hit. How much confusion and how many collateral matters do we want to give to the jury to try and confuse them? And that's specifically what 608 bars, is any collateral information that would be cause for confusion, and that's what we have here. I also think that it's very important to point out that when looking at defense counsel's cross-examination of the victim, it was focused primarily on matters that were outside of the actual sexual abuse and the elements that the prosecution and the people needed to prove. And when looking at that defense counsel's cross-examination, it was focused on impeachment and character for truthfulness and other areas in which he felt like she could attack. But when it got to the actual sexual assault that took place in the defendant's bedroom, there were no questions because the victim had always been clear and concise. And as this court is aware, the victim's statement need not be corroborated in a crime of criminal sexual conduct. And the jury believed the victim and the descriptions that she gave about how the sexual assault took place, the other specific things like what he was wearing, the shirt he was wearing, where he ejaculated, the condom that was used and where the condom was. Defense counsel also wants to argue that this was a he said, she said type case, but when looking at other corroborating factors that we had and that I had in trial to work with, there were certainly a lot of things that I was able to draw out, specifically comments that the defendant made to the victim shortly thereafter, specifically relating to, hey, yeah, that happened, I don't want to get you in trouble, you don't want to get me in trouble, let's not talk about this. And as your honors are aware, the defendants and statements against interest are so powerful and so strong, especially in a criminal sexual conduct case. And that's specifically what we had here, and the jury found the victim to be credible.
Well, let's assume I disagree with the notion that the evidence shouldn't have come in, that cross-examination should have been permitted. What do we do with the fact that the jury got a deadlock instruction? Because then, of course, we have to decide, would it have made a difference here, And does the fact that the jury was deadlocked and clearly having a hard time for a few days on this make a difference?
Yeah, and that's a great point, Your Honor, and I appreciate you bringing up that question, because I think one thing that we need to look at is the last count was the assault with intent to commit penetration. And looking back, that is a very convoluted jury instruction with an assault. What is an assault? What was the penetration? So we don't know what the status of the deliberations were. And the jury came back not guilty on that last count 3 of criminal sexual conduct, or assault with intent to commit penetration. And I mean, the same can be said, that could have been their hang-up. There's just so much more that goes into that. And I also want to bring to the court's attention that when the deliberations were ongoing, the jury re-listened to testimony. So that alone and getting that set up, I know defense counsel wants to argue that they deliberated for a day and a half, but how much of that time was also getting the technology in order, making sure they can re-listen to the testimony and all of those things. And that takes a long time for any courts to produce to the jury. This was also a trial that was done during COVID, which obviously we had 2 separate courtrooms going where the jury deliberations were not in a deliberation room, but they were actually in a different entire courtroom. So that caused certain delays, but I don't want to put too much credence into the amount of time that the jury was deliberating and whether or not that should be a sign that they struggle with certain issues, because re-listening to everyone's testimony and the number of people that they listen to over and again certainly would make the deliberations longer and more drawn out. One additional argument that I would like to make to the court in regards to People versus Douglas is that was clear and beyond the pales of any principled outcome that I want to bring. I mean, this is a situation in which the victim was able, and other people were able to testify specifically to what that victim talked about outside of the courtroom. And I think in Douglas, the victim on the stand, from the facts that I gleaned from the case, shows that she was unsure about whether or not the penis went into the mouth of the defendant. She was unsure what specifically happened and had to be drawn out. This is not that case. Our victim in this case was specific about what happened, the pain that she felt when the defendant's penis entered her vagina, the shirt that he was wearing, how he was laying when the penis went into her mouth, and where the defendant eventually ejaculated into her mouth as well as onto himself. And she was specific about that. And in People versus Douglas, the testimony and the other evidence that came in is certainly not this. This was a case in which the victim was clear and concise about what happened, and she was impeached over and over and over again about other acts and other things that happened about Awan and Xavier, specifically relating to when she initially disclosed what took place and what happened. And I think that is so important for the court to realize that she was impeached so many different times, not about what she told a volleyball coach, not in a police scene, but what she told people about what happened with the defendant, Mr. Sale. And for those reasons, I don't believe that, even if the court rules that under 608, that it should have come in, that any information that would have come from this would be outcome determinative. Thank you. No further.
All right, I've got just over a minute left, so I'm going to hop around a little bit here. Regarding the nature of the inconsistency about severity, this is page 221 of the transcript. This is defense counsel. The issue is that she reported it as not an accidental hit. So the intentional versus accidental, I think, was put on the record. I think that's what trial counsel meant by severity in the moment when the judge put her on the spot. The idea that this was collateral, I think effective impeachment is often collateral. I mean, let's imagine a case where there was a prior false allegation of sexual assault that the complainant had made. That's kind of the pinnacle of impeachment in these cases. Obviously, that would be collateral to the merits of this particular case, but it would still be very effective impeachment, even though collateral. Finally, about the deadlock, I think, if my memory serves, the jury deadlocked after re-listening to most or the majority of the evidence that they asked for. So I think that shows how close this case was and that the error here was not harmless. Thank you, Your Honors.
Thank you both. The case will be submitted.